The Bill of Rights notes. Now, a couple things to recognize and to remember when we're discussing the Bill of Rights is that they are not absolute. A number of things might get in the way of exercising those rights. For example, you have the right to free speech, but you certainly can't yell bomb on a plane. You have the right to practice or to exercise your own religion, but your religion can't infringe upon the rights of the others. There are so many sort of lines in the sand. There are so many different specific details that come about with the change of society and with the change of the government, with the change of the people, that the Bill of Rights are always being interpreted by the courts and new situations are always arising. So this interpretation needs to continue. Also, the Bill of Rights are not limited to individuals. You'll see soon here that various amendments address groups as well as states. The First Amendment is it has a handful of rights within it. The freedom of and from religion. If you recall, the term clause means sort of a part of a sentence or an idea within the sentence. There's in the First Amendment an establishment clause, which basically makes sure that there is no national religion, that there's no religion that's going to be pressed down upon the people based on the government's decisions. Also, the free exercise clause. Not only will the government promise not to have an official religion nationally, of course, but people are allowed to exercise whatever religion they want, as long as it does not harm society or other people. Freedom of speech. This means you have the right to advocate ideas. There's three different kinds of speech: pure speech, speech plus, and symbolic speech. So pure speech is standing up, like you see the guy in the Norman Rockwell painting on the top left. Speech plus is when you're advocating something in a more public fashion and in different ways, like pamphlets or whatever. And symbolic speech is when you don't really use words, you just use symbolism. Like I think famous examples, Tinker versus Des Moines, where some school students protested the Vietnam War and they wore a black armband. They were suspended. Later it was found by the Supreme Court that they had the constitutional right for the symbolic speech because it wasn't hurting anybody. Framers intended to protect political speech. Speech must also not endanger citizens. Of course, this is that is found in the Schenck versus the United States Supreme Court case in 1919 that found that in the time of clear and present danger, the national government can restrict speech. Also, freedom of speech does not cover obscenity. According to the Supreme Court, something is obscene if it is portrays in a patently offensive way, sexual conduct by state statute. Statute is a word for law, or taken as a whole, basically is pointless except for whatever obscene thing that it's trying to promote. No serious literary, artistic, political, or social value. So freedom of speech is covered except for in times of war, in times of sort of extreme danger, also when that speech hurts other people, and obscenity does not count as freedom of speech. Freedom of the press is one of the most basic rights and one of the most important rights that the United States has. The press is really the mouthpiece for the United States. It's really the communication to the people about what's going on in the country and with the government. Much of this is very similar to freedom of speech. A lot of them are tied together. However, there are some publications that are not allowed. Slander, which is speech that damages a person's good name, character, or reputation by obvious lies. I'm sorry, my numbers are messed up there a little bit. And libel, which is a printed, written account that is defamatory. Peaceful assembly is a really important right as well. You'll notice that these are all in the First Amendment, which means that sort of shows the weight that the founders had for these. Over the course of history, freedom of assembly has protected individuals from espousing a myriad of viewpoints. This has been able to sort of publicize people's opinion and hope to gather support for their position. Striking workers, civil rights advocates, anti-war demonstrators, even KKK marching. So peaceful assembly is something that people have. They have the right to do that. Now, the KKK can go ahead and apply, for example, like at Marion City, to apply to, march down the street. But if the city of Marion decides that them marching down the street would cause too much turmoil and potential violence, the city of Marion can go ahead and say no to them. The last thing is something I think we take for granted a lot. We can ask the government to right a wrong or correct a problem. We can write a letter to the Obama administration and say, we don't like what you're doing, we think you should do this, etc. We don't fear reprisal. It allows citizens to focus government attention on unresolved ills. It can bring attention to some sort of political problem that hasn't been addressed. Provide information to elected leaders about unpopular policies, and expose misconduct, waste, corruption, and incompetence. So the right to petition is the right essentially to accuse your government of certain things and without being thrown in jail for it. So the Second Amendment is written very oddly. And if you look at it, it's written in a way that's very unclear. So there's a lot of actual English arguments about it. What exactly did they read? So the amendment goes like this: a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. So what is that doing? Is that listing things off? A well-regulated militia, being necessary to the security of the state, the right of the people to keep and bear arms, saying that militia and the right of people to keep and bear arms are two different things, and they shall not be infringed, or is expanding on militia. A well-regulated militia shall not be infringed is sort of the two bookends of that amendment. And in the middle are these two clauses: being necessary to the security of the free state, the right of the people to keep and bear arms. So the question is it only about militia? Each state has that ability? Or is that second part that says the right of the people to keep and bear arms, is that talking specifically about the right to keep and bear arms? Okay? And if you haven't noticed, it's been constitutionally determined that those two, both of those things are constitutional. So you can have a gun if you'd like. Third Amendment. This is the protection of quartering troops. This is not cutting troops in four. This is actually allowing the troops basically coming in and taking control of your home and your food, etc., as a service that you would provide to them, that you would need to provide to them in order for them to fight for you. This happened during the French and Indian War in 1763, so the founders were really upset about it, but this has not happened since. This has not been a Supreme Court case in the United States. Poor little Third Amendment. So the Fourth Amendment, this is the one, fourth, fifth, and sixth are sort of combined. I always think of the fourth as like when you get arrested, fifth is the process of being processed, I guess, and the sixth is being tried. So the Fourth Amendment guarantees a protection from unreasonable search and seizure. So that word unreasonable, again, what does that mean? So typically, it's been established by law that if the police are going to search your premises or your stuff, or if the police are going to look for things that you've done wrong, they have to have a warrant. A warrant, of course, is when they go to a judge, they say, here's the evidence, do you agree that I should be able to search for them? And then the judge says yes, and then they can go search your stuff. So it's sort of like a double check. So the police can't just search your stuff without a warrant. But there are a handful of exceptions, and these are actually pretty consequential. School, and we'll talk about that in a little bit, but basically you go to a public school, everything in the school is liable to be searched. You don't have reasonable expectation for it to be private. You don't have any ways, you don't have, it's not guaranteed that you have privacy here. So automobile, it moves, so therefore police officers, that is different than, let's say, your house. There's something called the Terry exception, which means, if the police officer has a good reason to think you're about to commit a crime, they can go ahead and search you. Let's say they think you're going to kill somebody. Once you're arrested, they can search whatever they want. Searches for evidence, border searches, they can do that no matter what, and plain view exception. So if they see something that you're doing illegal, they can then go ahead and search your vehicle or your house. There are extingent circumstances like the house is burning, criminal trying to escape, etc., that also don't require the police officer to go grab a warrant real quick from a judge who's far away. So this is from the Linn-Mar Student Handbook, page 4, and I just thought I'd throw some of these up here so you could look at it. The canine inspection, Linn-Mar High School in cooperation with the Marion PD conducts routine building inspections using canine units. These are drug sniffing dogs, right? These inspections are done during, before, and after school. If there's reasonable, if a drug dog hits on your car, that's reasonable suspicion, and they can go ahead and do a search. If that's in your backpack, if that's in your locker, if that's in your car, the canine inspection is okay. Now, is that random canine inspection okay in your house? That's just been a matter of a Supreme Court in the last couple of years. And no, they can't, bring the dog up to the porch of the house, and if it hits sniff some drugs or whatever, it can't go in. It doesn't cause for them. That doesn't replace a warrant. Lockers. We'll pretend that people actually use lockers here at Linn-Mar High School. Basically, the beginning part of this goes through and talks about just the specifics of the locker, but at the end, it talks about although school lockers are temporarily assigned to the individual, they remain the property of the school and are subject to regular general inspections by school officials. Contraband items discovered during such searches shall be confiscated by school officials and may be released to enforcement of officials. You do not have a reasonable expectation to believe that your reasonable expectation to privacy in your lockers. Mobile devices, basically, right now, can we go in and look at your text messages, and can we go in and look at your Twitter and your apps and everything else? Not right now. I'm not sure where the line is going to be drawn on that, but certainly mobile devices, on the very bottom you can see mobile devices may be temporarily confiscated at the discretion of a teacher, staff member, student, dean, or administrator for inappropriate use or disruption. So that is not a right that you have. If you use it, if it's disrupting school, if it's disrupting the school environment or the learning environment, basically teachers or administrators can take that from you. Can they look through it? Again, no. So on page 30, all school property is held in trust by the board of directors. School authorities may, without a search warrant, search a student lockers, desk work areas, or student automobiles under the circumstances outlined in regulation 502.4R, which is actually next. In order to maintain discipline and order in the school, promote the educational environment, and protect the safety and welfare of students and school personnel. Again, school authorities may seize any illegal, unauthorized, or contraband materials discovered in the search. So, in order to protect the health and safety of the students, basically, school officials can go through and search your stuff if any of these 4 things happen. If there's an eyewitness observation by the employees, information received from reliable sources, and again, what's reliable? That's a great question. Suspicious behavior by the student, or if the student has a past history with some of those sort of bad things. But that can't be used by itself. It's got to be used in combination with 1, 2, or 3. But so let's say number 2, information received from a not so reliable source, but number 4 is in effect, which is, this student has gotten into a lot of trouble. So that will constitute, those things combined can constitute a search. Basically, search will be permissible, and it goes on and talks about the specific parts of that you can go ahead and have confiscated. So we can move on here to the Fifth Amendment. The Fifth Amendment has a handful of parts, and this is how you're sort of processed. This is part of the due process of the government. You have the right to a grand jury indictment. A grand jury indictment means a large jury of your peers will look at the evidence and determine whether there's enough evidence to actually have a case or not. This doesn't mean you're guilty or innocent. It simply means, is there enough evidence to actually make this a case? That's what indictment means. Also, you have protection from double jeopardy. You may not be charged twice for the same crime. So this is a really important right that we have, but not all countries do. Protection from self-incrimination. This is when being investigated or when you're being arrested or interrogated, you can plead the Fifth. I don't have to tell you if it's, you don't have to speak, you don't have to incriminate yourself, etc. Now, sometimes this can make you look guilty, but also it's such a basic right that you can go ahead and deny the, you can deny speaking, you can claim the Fifth until you have a lawyer around without looking guilty as well. Also, the Fifth Amendment promises you, equal protection under due process of law. And this means substantive and procedural. Substantive means like the substance of the actual laws. If you sue or if you claim that your Fifth Amendment is being violated because the law itself is against you or is bad, then you're doing the substantive. If you are suing or claiming that the procedure which you got arrested violated your rights, then that is procedural. And the last part of the Fifth Amendment is the federal government has a right to eminent domain. This should be indented, not number 6. Basically, if the government can prove its need for private land, it may have it, it will have it, as long as they provide just compensation. Usually there's an arbitrator, and a third party who looks at the value of the land or the items and determines a number that the federal government must pay the owner in order to take that property. But if the federal government wants it and they can pay you enough money, and they have, and they determine what's a fair amount, it doesn't matter how badly you do or do not want them to have it, they can. The Sixth Amendment is the process of the trial. Many people waive the first one, a speedy and public trial. Speedy may be limited due to the number of cases. It takes forever nowadays to get a case through the courts, and a lot of people waive their right. They don't want cameras there, or they don't need it to be fast. It's not a big deal. But this is a way to prevent people from being, arrested and held indefinitely. And the trial date keep getting pushed back. Public may be limited for the protection of minors as witness, or if the citizens in the gallery become unruly. Each court case and each judge can decide if they want to allow cameras in the court or not. You have the right to a jury. The defendant may waive this right, in situations where you got caught. A lot of criminal court cases or, like OWIs or traffic violations, people don't. It's an expense that they don't want to have to pay because you have to pay court costs if you lose. And it's sort of stupid to do that when you're obviously guilty. So a lot of people do waive the right. Juveniles do not have the right to have a jury. You must be informed of the charges against you. You have the right to an attorney. And again, with Gideon and Wainwright later, you'll notice that that right to attorney will eventually mean a public defender if you can't afford one. You have the right to confront witnesses against you, and you have the right to call witnesses on your behalf. Essentially, that whole process of interrogation and cross-interrogation is outlined in this Sixth Amendment. The Seventh Amendment guarantees the right to a jury in civil cases in federal courts. This is not guaranteed in state courts still, so it's relatively minor. The Eighth Amendment, protection from excessive fines or bails. Fines and bails must meet the seriousness of the crime. You can't be fined $5 million for, jaywalking or something like that. And you certainly need to have a normal amount of bail in order to be able to and that must equal the crime. So bail is you post a certain amount of money and give that to the court and say, I promise to be here on the court date. And then what they do is they release you from jail with that promise of that. And if you skip bail or whatever, if you don't show up on that day, then you owe the entire amount and you're in trouble. Also, the Eighth Amendment prohibits cruel and unusual punishments. But what is cruel and unusual? It depends on what time period you're from. Early United States, hanging was normal. Even firing squad was normal. There's a guy in, I think, Utah a couple of years ago who chose the option to die by a firing squad, which is extremely unusual, and many states have not allowed that. The electrical chair is something that was really popular for a real long time, but, people are, society has determined that may, in certain states, might start considering that cruel and unusual. Nowadays, people die of or put to death of a drug cocktail, largely. Which knocks you out or makes you not feel anything, knocks you out, and then kills you. It's like a three-step process. The Ninth Amendment essentially says because the right isn't listed doesn't mean it doesn't exist. Reiterates the view of nature of man in the Declaration of Independence, and this answered the Federalist concern of excluding rights. If you recall, one of their arguments against the Bill of Rights was, hey, what happens if we don't list them all out? We didn't say that the government couldn't, steal our monkeys. So what happens if they can steal our monkeys? That's a ridiculous idea, but so is the idea of listing out every single right. Well, this ninth is sort of a catch-all. In modern use, it has come to protect personal bodily privacy. Roe versus Wade was decided largely on this amendment and actually established some sort of bodily privacy as a precedent. But this was not how it was originally used, but has been since. The 10th Amendment is, again, a catch-all. If it's not listed here, if it's not given to the national government, then it's given to the states. This was added to calm the anti-federalist fears and help the Constitution get ratified. Okay, so all of those were originally, well, it's hard to tell what they were originally included to encompass, but the only time any of those amendments say anything about whether it's a state or federal government that they are making protections for is in the first one. It says Congress shall make no law. So outside of that, that means that there's essentially no guidelines to whether or not that these Bill of Rights have to do with states or not, or are they just a federal protection? So Barron versus Baltimore is an 1833 Supreme Court case that essentially says they're separate. States can do what they want. The Bill of Rights are only for national purposes. So they created what's called a dual citizenship, meaning you are a citizen of the state and a citizen of the country. And as a citizen of the country, you have these Bill of Rights protection from the government, the federal government, but the states have their own choice. However, in 1868, after the Civil War, there is what's called the 14th Amendment. Now, the 14th Amendment was largely focusing on black people, on freed slaves after the Civil War. So there's sort of two different parts. All persons born or naturalized in the U.S. are citizens of the United States. Former slaves are now citizens. Then this next part says, nor shall any state deprive any person of life, liberty, or property without due process of law. Okay, there's one clause, due process clause. Then the other clause is, nor deny any person with this in its jurisdiction the equal protection of the laws, which is equal protection clause. So does this apply to the state governments? No. In 1873, there was a slaughterhouse cases that basically said, you know what, no, these do not apply to, the Supreme Court said these do not apply to states, and this is only, the 14th Amendment is only protecting black people. It's only defining citizenship for black people. The 14th Amendment intention was not to apply the Bill of Rights to every single state, to force the states to follow each of those Bill of Rights. But since then, there's been, it's called selective. It's been selectively, the Supreme Court has slowly applied selective application. Each one of these rights that we've talked about has slowly applied them to the states. All, except trial by grand jury, petite jury, and civil cases, have really been applied to the state governments. The Third Amendment too, because that's never been a Supreme Court case. The Third Amendment applies as well. But so slowly, this has been increasing this has been tied to the states. The most recent amendment is the 27th. I just threw this on here because it was ratified. The most recently is 1992. This was proposed originally with the Bill of Rights, but was never ratified. And it seems to make sense. No Congress can give itself a pay raise it can't actually take any increased checks until after the next election. So instead of giving yourself a raise and getting the raise right away, you have to wait until you win an election to sort of earn it.